We are fortunate in that we have this honourable bench to review the various arguments dispassionately and professionally. And we know that this honourable bench, despite our struggling with the various redactions that have considerably reduced our ability to make comprehensive submissions in open session, we know that this bench will assess our arguments faithfully. We have provided a comprehensive analysis of both the law and the charged incidents. We have attacked every single count in open session while doing our very best to respect the restrictions imposed upon us and applied by the prosecution to its charging document and pre-confirmation brief. And these redactions have not just been a few here and there, they have been so sweeping that virtually nothing intelligible remains of the 49 incidents that we have been talking about for the public to read and to understand. This inequality of arms in the public eye expresses itself in the way the prosecution controls the narrative by arbitrarily lifting redactions so that it can make its narrative of a grand scheme of co-perpetration known to the public in open court, while the defence can only meaningfully attack the real meat and the substance of the charges, either obliquely or in closed session.
The Chamber, my colleagues and myself, we have the duty to recall certain issues. First of all, the redactions that you have mentioned now, it was already raised by the defense, and the Chamber had taken a decision rejecting the position of the defense. The number of the decision is 388. And I should say that the quality of arms is ensured because the defense has access to the redacted information. It just is not available to the public.
And then, exactly in the spirit of the waiver filed with this court, he looked at me solemnly and said, "Mr. Kaufman, Nick, I have done my duty and I have left my legacy. Go to court and do your job, but I can no longer help you. I no longer remember much at all, and I can't comment on people who I do not know and on statistics that mean nothing to me."
Yeah, thank you, Your Honor. I don't want to stand up and object to my friend, but I would request and ask that you strike and not take any account of any word that my friend said came from his client. None of that was responsive to arguments, which is what these last 30 minutes were about. You made that clear on pages 24 and 25 of the transcript today, and it's in paragraph 9 of your order on the conduct of the hearings. Second of all, my friend can't testify for his client or make a speech for his client. That's governed by Article 67H. If he wanted to come here, he didn't want to come here, he could have come here and talked about whatever he wanted to, but he chose not to. Mr. Kaufman's conveying this. He's been complaining about hearsay all day. It's not reliable, but beyond that, if Mr. Duterte wants to speak to the court and speak to the gallery, he should come here, request to make an unsworn statement. He shouldn't do that through his counsel. So I ask that all of that be given zero weight whatsoever in your determinations. Thank you.
Madam President, but I do believe that the defence has the right to respond.
Wait.
Yes, says Judge Mota.
And I say to Mr. Nichols that this was not testimony. It was purely an explanation for him not coming to the hearing. He has the maximum respect, obviously, for your honours, but he has his arguments, which we shan't repeat here once again. They were all set out in the waiver. That was not testimony, I assure you, Mr. Nichols.